So statutes, sort of wide breadth statutes that are in play here as a federal employee and private employee as well. The landmark statute being the Title VII Civil Rights Act of 1964, as amended over the years. Basically, when we're talking about EEO law, we're talking about discrimination, right? I mean, it is the name of the game. It's all about that causation evidence as we get forward here, as far as when you're issue spotting. Basically, when you're talking about filing an EEO complaint against a federal executive agency, we're talking about disparate treatment. And how and what bases are we looking at? We're looking at race, sex, national origin, religious affiliation, disability status, age, or prior EEO activity. I mean, that's the name of the game when you're looking into these cases, causation evidence based on those protected claims. Oftentimes, I'm sure there's slides on this, but employees are more savvy, or if they are into discrimination, which is unlawful, of course, you'll see it in more of a context of comparator evidence. You're not going to see much in inferences of discrimination and aspects that aren't direct evidence of discrimination, right? The racial animus, as far as commentary and those type of things, are very infrequent. So what you're doing is basically building a case based on circumstantial evidence, and that's a lot of what these cases are about. But at the end of the day, it's showing more likely than not these things, the events that a client experienced in the workplace were motivated by one or more of these protected classifications. Age Discrimination Employee Act of 1967, that was adding on age for individuals age 40 or older. And again, you're looking at treatment of coworkers vis-a-vis, substantially younger standard. Rehabilitation Act of 1973, and that gets into the disability discrimination aspects of a case. A number of different prongs there. Disparate treatment and disability being one, and reasonable accommodation being another, large component of that law. So then we do have some additions that have been codified through case law and then through regulation over the years. The Genetic Information Discrimination Act of 2008, rather narrow subset of laws, but that does prohibit, various things in the workplace, including genetic tests and diseases of an employee's family member. So, more of a narrow fact pattern there, but it is something that is seen from time to time. Retaliation, more prevalent. When you're looking at retaliation, it's based on, oftentimes you're asking retaliation based on what, and it has to be obviously based on some sort of EEO foundation, right? And that's when you're looking to opposition clause or a participation clause. So you're opposing something in the workplace, again, the racial discriminatory comment, you say to the boss, I don't appreciate you talking to my coworker Sally Smith that way. It's racial in nature. And then based on that opposition activity, you're targeted in the workplace. That could violate the opposition clause of Title VII. Similarly, participation clause, you're participating in your own EEO complaint. For example, you go to that EEO counselor, you initiate the EEO process, and then based on that participation, you are targeted in the workplace. That's a different prong within the anti-retaliation provision of Title VII, but equally as unlawful. So really the two foundations of that cause of action. So here we get into, again, just basic primers here of what we're talking about when we are talking about race or color discrimination. They are different. They are used somewhat synonymously for complainants that file these complaints, but they are slightly different. Race discrimination involves treating someone differently based on a certain race or characteristics associated with that race, right? Color discrimination, on the other hand, is really based on skin color. So, think of any protected classification, whether it be a Caucasian person, an African-American person, whatever the case may be, that differentiation based on the actual color of the skin, whether that be lighter complexion or darker complexion, technically is not a racial classification under the definition as understood under EEO guidance, but rather it's color-based discrimination. So equally as unlawful, just basically semantics there on how that is framed. When you are checking the boxes, these things do matter, and it's important to be articulate about them. Oftentimes when you're getting into a situation down the road where you have to prove your case, I mean, ultimately is your burden to prove as a complainant to show by majority evidence that these things were motivated by one or more of these things. You don't want to be bogged down in trying to prove, for example, color discrimination case when it actually is a race discrimination case. There's different rubrics, there's different burdens of proof. So, you want to be credible to the fact finder, and you want to properly identify these things. So more times than not, it is a race-based case if you are making that distinguishing element between race or color, but they are still both protected under statute. Sex discrimination, part of Title VII as well. Basically, it prohibits discrimination based on a person's sex. It includes gender identity or sexual orientation. That's, not anything, that has been extremely recent developments in the law. It's been a number of years that those identities have been protected. Sexual harassment means harassing someone based on their sex, includes unwelcome sexual advances, requests for sexual favors, and verbal or physical harassment of a sexual nature. So this is really the crux of what Title VII derived from, was sexual harassment in the workplace. Whether it is a harassment-based theory, as is noted here, or sort of a quid pro quo situation where you have someone in management that is trying to exploit that subordinate employer relationship. So that's something to keep in mind. But again, different sort of causes of action within that subset of sex-based discrimination. Sexual harassment is illegal when frequent or severe, that it creates a hostile or offensive work environment, or when it results in an adverse employment decision, such as the victim being fired or demoted. So that is really sort of a pendulum type analysis. You have the level of severity and pervasiveness of that conduct, and whether or not that rises to the level of unlawful treatment in the workplace. And there is a well-developed body of case law on that subject, but really those two things are sort of viewed in tandem. The law does not prohibit simple teasing, offhand comments, or isolated incidences of not very serious. That's true. Again, it's a scale, right? So one simple offhand comment would not be unlawful, but these repeated incidences eventually do rise to that level. Harassment is legal when it is based on other protected categories as well. That's true. So that's something to keep in mind, whether it's race, national origin, religious affiliation, disability status, whatever the underlying Title VII bases is at issue in the case, that harassment legal body still applies. So yeah, that's still the severity and pervasiveness of the action is going to be reviewed by an adjudicator, no matter what bases we're talking about here under Title VII. Discrimination based on disability. So you see the definition there: physical or mental impairment that substantially limits one or more life activities. A record of physical or mental impairment that substantially limits a major life activity, and an actual or perceived impairment that is both not transitory or transitionary and minor. Okay. So basically, what are we talking about here? Very broad. I mean, disability under the law is very broadly implied. It's not necessarily really where you see the gravamen of the fight, right? It was whether or not you're disabled. As long as it's not temporary in nature, you're looking at something that is that substantially limits one or more life activities. Likely it is protected under the law. Of course, it is fact specific. I mean, sometimes there is issues about that. I mean, for example, years ago when, we were dealing with COVID, right? I mean, by the technical nature of the law at that time, COVID was not a disability, right? Because it was transitory in nature, just like a common cold or flu. So, the issue then became under employment law, how are you going to treat that specific sort of subset of an illness, if you will? But if you're talking about traditional disability, I mean, if it is something that's going to substantially limit a major life activity, it's something that's not temporary, it's likely covered by the Act. So assuming that we are in the world of a protected activity, then the question becomes a lot often work about reasonable accommodations, right? How can I, as the employee, complete my work, protected under the act with or without proper accommodation? Crux of it is whether or not the employee can perform the essential functions of the position with or without accommodation. If the answer to that is no, then the person is not entitled to an accommodation. Needs to be some sort of accommodation that allows that individual, or no accommodation at all, to perform the essential functions of that position. So, once we're into that world of, okay, but for this disability that needs accommodation, I can complete my job as a federal employee, then what? Well, then is the interactive process. It's really this process designed under the law to be interactive in nature, for both parties to make a good faith effort to determine the appropriate accommodation moving forward that would allow a disabled employee to return to work, if that's the case, or potentially duty shifting in the workplace itself for that individual to properly complete the essential functions of the position. So that is a fact specific issue with every case when you're getting into that. It's an effective accommodation. It's not necessarily a preferred accommodation. It's whether or not the employee can perform those duties with or without a reasonable accommodation. So, there is that interplay through the employee and his or her physician, as well as the agency and the position description itself on what is considered essential in that position. The employer can evoke affirmative defense here, and an undue hardship. An employer need not accommodate those requests that pose an undue hardship on the employer when considered in light of factors such as the employer's size, financial resources, nature, and structure of operations. You see it from time to time in the federal sector, but oftentimes it's not necessarily a winner, right? You're dealing with federal agencies in many cases that have hundreds and if not thousands of federal employees with untold resources, oftentimes, can be in the Department of Defense case, billions of dollars, right? So you're not going to necessarily say, hey, this keyboard costs the undue burden to my organizational structure, right? So you don't often see that in the federal context. Sometimes you do. Depending, of course, on the expense of the requested situation, maybe apparatus in the workplace. I mean, you often see it sometimes in telework arrangements, right? Our stakeholders are in person. We can't accommodate full-time telework. We need that individual to be in the workspace X, Y, and Z dates during a given pay period or whatever the case may be. So you see it more in that context, but from a financial perspective, less frequent in the federal sector. Okay, we can maybe touch on that later on. Discrimination based on religion. Honestly, we don't see a whole lot on this as much. I mean, there was a point in time where we're seeing more of those cases. Again, sort of the COVID era and maybe regulations that were being unveiled at that time, based on vaccination policies, masking, etc. It's more of a narrow subset, again, fact specific. But in any event, Title VII does prohibit religion based on discrimination. Based on religion. Discrimination that prohibits discrimination based on religion or religious affiliation. It also likewise requires an employer to accommodate any kind of religious practice that are sincerely held beliefs. So that's part of the law. So all that being said, now you're thinking to yourself, okay, having some sort of breakdown in the employee-employer relationship, I'm questioning, whether or not I do have a cause of action to move forward. What do I do? Well, as discussed, the first thing is to sort of identify one of these bases, right? I mean, the harm oftentimes is the easiest part of the proving structure, right? I was suspended from work for 14 days, and I think that was unjustified. And I want to, air my grievance in some sort of forum. And I think that it may be EEO related. Well, very well could be. But first of all, we need to identify the protected bases, right? So that's point one. That ties into the second point here, the universal jerk defense. I mean, you see that from time to time with agency managers. I mean, we have an equal opportunity boss that's a jerk, right? hard to bring a cause of action against those type of employers because they can show consistency in the case of, maybe a suspension or something like that. I called the employee wasn't, didn't pick up their phone. They were supposed to be at their duty station and I'm suspending them for 5 days. Well, that's seems pretty draconian on its face. Maybe it is disparate treatment, but then you get further down the line and this responsible managing official can show consistency in treatments through employees 1 through 5 under their supervision where they all got 5-day suspensions. Well, and there's a mix of races and sexes and national origins and disability statuses and EEO activity, past EEO activity, whatever the case may be. Well, again, disparate treatment is hard to prove on that fact pattern. So, you have to understand a bit, I would say, of the personality sort of dimensions within your group, within the division, whatever the case may be. Familiarize yourself on what you need to in order to establish successfully proving your discrimination claim. And again, majority evidence showing that it was more likely than not that one of these protected bases ultimately motivated the the personnel actions. So that's what you want to think about. So now we're getting into actually filing the informal complaint. So by regulation, that's specific to federal agencies under 29 CFR 1614, there is requirements as well as the EEO MD 110 that sets out what these federal agencies must do. And one of these things that they must do is identify an EEO counselor that needs to be publicized within your office, where to go, how to contact that person. And agencies do it differently. Some are, 1-800 call number. Some are a Civil Rights Division email hotline. Some are actually live people. So it all does vary, but there has to be some sort of procedures that are defined by law on how to contact that individual. And then now, okay, let's go forward and we're contacting an individual. I mean, it's certainly our practice to memorialize that contact. As we go forward here, there's important rigid deadlines, right? Here, you're likely talking about a 45-day deadline. So, bad thing happens to you at work. In the case of the suspension, that's a discrete personnel action. You're on the clock. You must initiate that contact within 45 days. So when you do eventually initiate that contact, you want to make sure that that's memorialized on quote unquote the record or something to cite back to at a later time to show, no, I actually did, initiate on that date. I have a read receipt from the counselor, or I have, my priority mail tracking that shows it was delivered to the EEO office, whatever the case may be, that is important to do. So then we're talking about framing your complaint. So how does that go about? So you can think of it as what we call notice pleading, right? You're putting the agency onto notice on what exactly is the issue in your informal EEO complaint. So, basically it's a who, what, why, where, and when. On this date, this actor, right? The agency through this actor did what or did not do what to me, right? So the case of a suspension on January 1st, 2005, the agency by and through responsible managing official, Jones, suspended me for 5 days for allegedly not reporting to work, which was unjustified, right? Something like that. You're giving the reader knowledge of the date, who was the actor, what happened to you, the fact that it was unfactual or whatever the case may be there. But it doesn't necessarily require a long narrative. It's not testimony. You're not building a quote unquote record. The purpose of informal EEO complaint is basically to seek early resolution. So you're not looking to, develop a record or call your witnesses or testify under oath to, exactly why you were sitting at your desk and you saw the phone ring at that date and time and you attempted to answer and then there was a, technical malfunction and you lost, contact with your supervisor and you were still ready and willing to report to work. You don't need to get into all that, right? You just need to get into the fact that this was the date, this is what happened, this was the discriminatory bases, right? So you're already identifying that. And you're making that claim known to the counselor to preserve your rights. It's known as administrative exhaustion. You want to notice your claim to that counselor, so there's no question. If you need to file a formal complaint in the back, those things will be satisfied. In most cases, the EEO counselor will recommend choices for conflict resolution. Okay, right. So informal EEO complaint is all about early resolution. As I noted, there are some different avenues in choosing the best way to do that. Or two, in fact. One is traditional counseling, which is a 30-day counseling period. In that case, an EEO counselor is going to act as the liaison between you, the complaining party, and agency management. They're going to basically somewhat get an account from management, as far as why they did what they did. Likely going to be something that's not discrimination, of course, right? Some lawful reason why they're taking that action. I tried to call this employee, 6 times, and I wasn't able to get a hold of him and her, and this was, the most important day in the agency's mission all year, and I'm suspending the employee. Okay, that's different than I suspended the employee for 5 days based on sex, right, or race. So you're not going to see that. You're going to see a lawful reason generally in the formal complaint process and informal complaint process. In that case, the counselor will turn around and go back to the employee and let him or her know the findings of the management's position. So it can be effective, but most of the time it quite honestly isn't. I mean, the other option is an ADR situation where you're having that discussion. It's a mediation, basically, an ADR, alternative dispute resolution. You're having a mediation with management. You can have your counsel there, your lawyer there. You can have whoever your assigned representative there. You can not have anyone there as well, but you can meet with management and sort of go over, your position that these things were unfair, unjust, and potentially discriminatory. Realistically, I subjectively at least believe at this juncture it was discriminatory. You might not have all the evidence there needed to prove those things, but you're there for a reason. It's EEO based. You have your ducks in a row. You're talking EEO language. You're talking disparate treatment. You're talking about, why I was suspended for 5 days when, they called, my counterpart that's outside of one or more of these protected classifications, and this guy got, a verbal counseling. Hey, you need to be at your desk. No suspension, right? That's disparate treatment. I believe I was targeted. So you're having that conversation with management at that point. Hopefully it's not the same RMO that in this case, hypothetical suspended you. It's another manager that can bring relief to the table, but you're trying to seek early resolution. What does that look like? It might be last chance agreement, right? You will be suspended for the 5 days, and we'll put that on abeyance. We'll not suspend you, but you need to be at your desk and, moving forward the next 30 or 60 days or whatever the case may be. It could be a clean record. It's going to be on your OPF for a year, and then we agree as management to rescind it. We'll, we see your position complaint, and we'll just rescind the whole thing right now and pay you the back pay for the 5 days. Whatever the case may be, the idea is that there's some sort of work towards resolution at that mediation table. Mediation can be extended traditionally beyond the 30-day period up to the maximum 90 days. Once you're at the ADR phase and you check that box, you want to go forward with the mediation, you're automatically within that 90-day period. Oftentimes the mediation does occur, closer to the end of counseling. So, agencies may use an outside mediator. They could use a contracting agency for the mediation itself. Obviously you're dealing with more than one individual at that point. You're dealing with likely, agency management, potentially an agency lawyer, an HR official. You're talking about a mediator. You as a complainant, and also your attorney. So there's a scheduling issue there, and oftentimes that takes time to work. In any event, you're trying to schedule that within the 90 days. So if there's no resolution, no harm, no foul. I mean, the thing with ADR, it's completely confidential settings. So you can come in there and say, you're listening to this webinar after the mediation, and you're not talking, discrimination language. You're talking about personality conflicts with your boss. He never liked me because, I never invited him to my wedding. And ever since then, we had a bad relationship, completely, outside of the bounds of EEO world. You're going to lose that case 100% of the time. But the good thing is, if you told that story at a mediation, it's confidential. So you're not going to be creating a record there. The agency lawyer can't cite back to that and say, there's no case here. Like this person said that, they brought up a non-EEO related reason. So there's no causation evidence here. The case should be dismissed. Can't do that because the mediation is confidential. All right, questions. So what avenue of law would one pursue for the universal jerk syndrome, aka possibly a non-protected category of harassment law? I mean, that's the difficult issue when you're dealing with really the tools in the tool belt, right? I mean, poor managers are not unlawful. The agency can staff poor managers that have poor people skills. I mean, presumably these managers are getting reviewed, right? They're under critical elements just like anyone else. And hopefully their subordinate or their supervising bosses would, their supervisors would identify that and hopefully work to some sort of performance metric to help, that individual improve their people skills if that's the case. But as far as sort of a broad stroke legal action, it becomes difficult. I mean, there is no law against it. So there's nothing, I guess, would be the short answer of it. But I mean, there's things to keep in, to keep mindful. Again, if there is even a heavier handed action taken by one of those individuals, it could certainly be unlawful. I mean, if you're getting to the level of federal employees and due process rights, you're talking about personnel actions as defined by Title V of the U.S. Code, which allows for MSPB appeal rights. So then you do have some sort of action. It's known as mitigation considerations, Douglas factors. So in traditional, appointment authorities that may be, either competitive or non-competitive appointments that do allow those rights, then you're looking at, mitigation issues. And in that case, you are looking about the reasonableness of conduct to some extent, right? So, I tried to call my subordinate. They weren't at their desk, and I'm issuing them not a 5-day suspension, but a notice of proposed removal. And, it comes to light in the record that this employee was a stellar employee. It's won, number of performance-based awards, had all glowing reviews, has a number of coworkers testifying to the extent that, this person is the best thing this director has ever seen, right? You have, a lot of favorable considerations the way in the employee's favorable, just showing that their quality of them as an employee. Well, then, that's not going to be sustained by an independent reviewer. So, to the lesser extent, when, the things that aren't considered personnel actions under, MSPB law, then there is very few sort of mechanisms to keep that type of supervisor in check. I mean, you can file an administrative grievance, hopefully that would be something that a supervisor would review over again, that RMO, if we're talking about, EEO law. But that would be sort of an action, would be an administrative grievance. You can always seek some sort of a grievance there. I mean, agencies have mediation procedures outside of EEO context too, to have those discussions with, potentially prickly bosses. But as far as the universal jerk, it's difficult. And then you get into the world of like a potential whistleblowing case, but without a fact pattern there, again, that could potentially bring this into the purview of the Whistleblower Enhancement Protection Act. And the short answer, there really is limited avenues there. But if you're dealing with something 15 days or more, and pay, then yeah, you do have a body that's looking into that, namely an MSPB judge. Yeah, again, some issues with the new administration. We will see, we'll see. I mean, obviously you can't through executive order change Title VII. So, to change regulation on how these cases are processed, I mean, it would be something that I think would be remote as far as likelihood, but you don't know. I mean, we don't know right now, I guess would be my thoughts on that. Confidentiality, that's a good question. And I saw that too on another one. I mean, if you're going through the EEO counseling and you're interested in the ADR process, by definition, you have to waive anonymity. So you would have to waive that so you could sit down, obviously, at a table to have a discussion across from a supervisor that can identify you, right? So, that's one thing, I guess, on the forms. The forms are fairly straightforward. The intake forms in EEO counseling phase, you're looking at name, your counselor's name, or I'm sorry, if you have any representative, his or her name. You might be, you would be at some point asked to identify the bases. You'd be asked to identify any kind of remedy you're looking for. What kind of remedy are you looking for in this process? And again, that's another reason to hire a lawyer, because they can help identify appropriate remedies and not just, something that is sort of your dream list at work, which, neither the agency is going to agree to or a third party in the form of a judge can award by law. So remedy is big, and that's something that, behooves you to seek legal counsel. Does having law counsel assist in framing the complaint, phrasing in the pre-complaint phase? Absolutely. I mean, I think that that's the biggest thing. Even if, your complaint is technically deemed timely, because there is workarounds to make a complaint timely. There is a theory of law out there. We talked briefly about harassment. So there is an aspect of law. So if you're under continuing harassment, if you timely plead one of those issues, right? I go to work timely every day. I report at 8 o'clock every day. My boss accusing me of being 5 minutes late, right? Every day this happens. So under the law, that first incident may or may not be timely, but that last incident, so you go through the EEO office. I just can't take this. Yesterday, my boss accused me of this again. It's just counterfactual. I want to go forward with an EEO complaint. Then the first instance would be lawful under the law, or timely under the law. So you could frame it as a continuing violation to get around some of those timeliness issues. However, oftentimes you see when individuals go forward with the informal complaint, they may or may be basically write a stream of consciousness in there and miss key issues, right? And then what happens is you file that formal complaint, basically regurgitating those what you're considering key issues, but you miss maybe several. Well, the EEO office is under no obligation to identify those issues you didn't raise in the counseling. So you're not going to be able to raise those claims later. So basically your claims just got narrowed, key aspects of it were, not considered. So, yeah, framing is probably the biggest reason in my mind, to hire a lawyer in the informal phase. And certainly having assistance at the mediation itself. I mean, most complainants that I've encountered over the years, it has take some sort of solace in having a lawyer sitting next to them, advocating for them. It's not all just adversarial, of course. I think that dovetailed another question I see, like what to expect during the mediation. It's really, sort of a fine line between showing the agency that you're speaking the EEO language, you have a case, you have competent counsel in which case to move forward, or, you do have the agency has exposure on a various fact pattern, so you want to be able to talk their talk, highlight the case, highlight issues, highlight damages, which is key. But then, not get adversarial, because it's not a trial. It's not fact finding. You're not going to be introducing documents. You're not going to try to convince maybe an agency lawyer that, you're going to win this case on summary judgment down the road or anything like that. It's not the nature of that, but you do want to show that you have a case, of course, and, you're at the table in good faith to seek early resolution. But you do want to sort of highlight those competencies of both your case and your representative. Do you have to wait for the informal process to be substantiated to file formal? So that's a common misconception. There is no substantiation of an informal complaint. You're not going to receive a report. You're not going to receive any validation that an EEO officer is going to come to you, and certainly shouldn't by law. The EEO office by law is neutral. So they should be on the management side. That's debatable. They're getting paid by agency money, so take that for what it is. But they're not supposed to be by law in anyone's camp or anything. So it would be inappropriate for an agency counselor to come to you after the 90 days and say, hey, I think you have a great case, you should go forward. Or contrarily, hey, this, management's going to kill you. And, the formal phase, I would just drop this now before, bad things happen to you, which would be potentially unlawful EEO reprisal, as we discussed, but that would be inappropriate at the very least. So there's no report or finding or thumbs up, thumbs down decision based on the informal complaint phase. In fact, there's none on the formal complaint phase. At the end of the formal complaint phase, we didn't get into it in great detail, but you file that formal complaint. There's by law an independent investigation occurs over the next 6 months. Pending any kind of amendment or anything like that, you get a report of investigation. There is no finding in that report of investigation generally. So, there's, it's not really a substantiation issue. Is it 45 calendar days or 45 business days? It's calendar days if the deadline falls on a weekend or a federal holiday is the next working day. What if you file beyond the 45 days? Does the agency still have to take it? In the informal phase, they don't have to take it. Oftentimes they will take it. They will take it, but the sort of the Pyrrhic victory there is they'll take it, but then when you file the formal complaint, they'll dismiss it. So, if you still have a grievance that beyond the 45 days, you could potentially go there. They could dismiss it. In my experience, I have seen them not necessarily honing in on the 45 days as much in the informal phase, but really the gatekeeper is when you file that formal complaint phase, assuming that early resolution failed, then the agency civil rights office will review that timeliness issue and will dismiss the cases. Can an employee be held accountable for falsely accusing someone during the informal complaint process? And I mean, I haven't seen, I'm sure there's egregious law out there, or I'm sorry, egregious fact pattern where they're using that process vexatiously. And in fact, there is some sanctioned issues I've seen, more so on the any kind of representative, and I've seen warnings, like stern warnings from adjudicators to complainants that abuse the EEO process. So it is possible, but if you have any kind of good faith belief that you're being discriminated against, absolutely not. I mean, that's what the process is there for. It's so you can bring claims of, EEO discrimination. This administrative process, I mean, at the end of the day, it is an administrative process, but there is you have federal court rights on these cases. So it's not supposed to be a bar to any kind of complaint or anything like that. But yeah, I mean, if it's used inappropriately, then certainly there's ramifications. All right, some of the ones here: how to file an EEO from outside when management is quashing claims. Again, this process is supposed to be neutral in definition. There is law requiring EEO counselors to be identified. You have an unfettered ability to seek EEO counseling. If that ability is in any way hindered by your supervisor, then likely they're violating the law. Per se reprisal, you do see these fact pattern quite frequently, relatively. Hey, if you go down to the EEO office, you're showing me you're not a team player. That's a violation of the law right there. Now, what kind of damages are you going to get for something like that comment? How did that damage you? I mean, that's the issue that you grab on those. But you can certainly get a piece of paper in your hands showing that you beat the agency in a civil rights case and they violated the law, which, has, I would argue, some value in of itself. How to fill out EEO forms. Talked about that a bit. A little specific, but guidelines on how to handle possible discrimination from management when they know you have a diagnosis of PTSD. I guess you could fill in any blank there of a disability. I mean, it's no different, right? In fact, you have, on a lesser element, so to speak, an obligation to show they had knowledge of the disability, right? You can't discriminate against someone if you don't have knowledge that they have a protected classification. So, it actually is part of the framework that you need to establish somehow that they had knowledge or likely had knowledge or constructive knowledge or some sort of variation of knowledge to show ultimately they discriminate against you based on that protected classification. What's the most common results if employees win? I mean, you get into damages there, right? I mean, EEOs are medial-based statutes. So you're looking at what they call status quo ante relief. What happened but for the discrimination? So it's like if you try to put that employee back into the position, but for the discrimination, what could you do to make that person whole? And that's an entire analysis on what to do there. But what I will say is there's no punitive damages in the federal government. So often you see employees come to us and they say, well, I want, $1 million and, whatever the case may be, massages for life, whatever, And I mean, maybe that has some sort of foundation and reasonableness, but the thing is, the law just requires make whole relief. How do you put that person back into a position to make whole relief in the, in the reality that there is a $300,000 compensatory damage cap in the federal space? Medical documentation, though, that's raised here, that is important to gather, and asks whether or not to submit it. I would not submit it in the informal complaint phase. It's, again, not a fact-finding endeavor. But certainly if you are, claiming compensatory damages based on distress to your emotional or physical well-being, then you're going to need that evidence. And it's something to contact your physician early, get that information, have it ready. So if you're at the mediation and you're well prepared, you can, and the agency's looking at you across the table, why should I pay you $50,000 and, exacerbation from your, PTSD symptoms? You can say, here are my documents. Here are what was going on at that time with my supervisor. Here shows my medical decline during that time period. Based on the law, I am entitled to non-pecuniary damages in the amount of, somewhere around $50,000 based on, what you're seeing here in these documents. So it is definitely something that you want to get on early, even if you're not submitting them to the counselor to try to evidence evidence your case. If you miss the time limit to move your case forward at the formal stage, what are the possibilities of appeal? I mean, they're very, very narrow. There are some out there, but that would be something you would need to discuss with a lawyer. A lot of times there is some sort of detrimental reliance aspect to that body of law to allow some sort of waiver of any kind of timeline. I guess there's one question about like being blacklisted as it relates to the EEO process. Like, how do you prove that claim? I mean, the reprisal body of law, you're talking about often a nexus, right? You're talking about trying to line up a timeline from reprisal, the protected activity, and the bad thing that happened to you at work, right? You know, I went to an EEOC hearing and I told my story before a judge for 3 days. An agency lawyer was sitting there next to me with, you know, countless agency witnesses. And I got back to my duty station that following Monday and I was given a proposed removal, right? Well, that starts to look a lot like EEO reprisal based on your protected activity, namely your participation in your own EEOC hearing, which is protected activity, certainly under the law. And then within a timeline, right? That timeline, that 3 days, you know, you were issued otherwise stellar employee, you're given a proposed removal. It starts to look like a presumption that that action was motivated not because of what's stated in that proposed removal, but rather your activity at the hearing the prior week. Is there a limit on attorney's fees that an agency usually pays? Interestingly, actually in the informal phase, there's no obligation for an agency to pay any fees, and that's written in regulation. Now, in experience, they do pay for fees because settlement's a compromise, right? And they know that you had to hire a lawyer to present your claims in a light most favorable to you at the mediation, and you incurred expense for that. So there is discussion there about fees and reimbursement of fees. Fees are interesting because actually, if you do win your case, you could be entitled to more fees than you're entitled that you paid out your lawyer based on market rates of those fees. So agencies are cognizant of that to some extent, and you know they're willing to broker fees in various aspects of the case. It depends on the agency. It depends on a lot of times their general counsel's office, their management chain, a whole host of factors, but there's not a limit on what they'll pay on attorney's fees. I mean, you could be, settling your EEO case after an administrative process, and then you're into federal court and you have well over $100,000 in fees, and they're all justifiable, and the agency could pay you every dollar fees, and that would not be uncommon. But there are agencies that, say we have no exposure in this case or limited exposure. So if you want to keep paying your lawyers, then we're not going to pay all your fees. So it depends. It is fact specific. Yeah, we had a question here about what if your agency doesn't agree to ADR, which is fine. I mean, it's not unlawful. Both parties, both the responding party and the complaining party need to agree to mediation. I mean, need to agree to that would potentially resolve the conflict. So, sometimes you see agencies not agree to mediation. I would say I would see that situation the most in a probationary firing case. Because probationary firing, well, oftentimes the complaining party is looking for a job back, and the agency, at that point has no record, no developed record, and often won't put that on the table during an informal mediation. So they're, not inclined to necessarily, sit through an informal mediation. But I don't see it that often. I mean, oftentimes the agencies understand that they have, they only have so many lawyers that field so many of these cases, right? These things are time intensive and expensive for both parties. So they're looking to resolve these things, early and often as well. I mean, it is really the infancy of a case. They understand it's a long process ahead of them, and cases are dynamic. A lot can change, but they'll definitely sit down and oftentimes listen in good faith and try to put something on the table to maybe address things early on. Now, given the fact that these things are time intensive and very long process, you're not going to get everything you might have wished for in a case, or you would be able to prove before a judge. In fact, I mean, they know that these cases to hire lawyers and going, years into this process is going to be a commitment, financial commitment, a resource commitment, time commitment, and they understand that. So, you might not get everything, you possibly could hope for by just simply writing down, a list of claims and sending them off to your EEO office. But that being said, I do find that agencies often will listen to their employees and try to hopefully, resolve the issue earlier before the case goes formal, and they have to hire an investigator, and they have to hire basically that investigator conducting a fair and impartial ROI, right? Complete a completely an ROI, which costs money, and then certainly they got to start hiring lawyers there if you proceed to an EEOC judge. So it is an opportune time to hopefully resolve, the case early on, which again is the purpose of the informal process itself. So that's everything. You can see our contact information here. Certainly welcome anyone to reach out to me on this webinar. Can certainly aim to assist you. And yeah, it's been a pleasure here to talk about these things with you.